Let's talk about expert determination. We can think of it as a form of arbitration, though it is a different qualification. I've done it about 20 years and I'm on the panel of the president of ICAEW to make such appointments. I've also written about it. My article on expert determination is on my institute's website, for example, and I was one of the first 5 to be accredited with the new qualification at the Academy of Experts, where I am now an examiner on expert determination. Typically, for an accountant, it will be to do with the purchase and sale of a company. The point is, the expert determiner is chosen from a suitable profession, and accountant EDs obviously value companies. So I would receive submissions from both sides, consider them, ask for responses, and eventually come out with an opinion of what the company was worth, which of course drives the amount which one party must pay to the other. The only technical difference between ED and arbitration is that the arbitrator's award is itself a judgment. With an ED finding, it is a finding of a contract, so that if one party fails to carry out the contract, they must go to court to have that finding rubber stamped. But that rarely, if ever, happens. There is a handful of cases where the court has overturned the decisions of an expert. One such is Begum and Hussain, which was to do with 2 ladies running an Indian restaurant through a company where one wanted to buy out the other. The expert didn't do as he was told. He was told he had to look at certain financial records, and he said, "I'm not going to do that because it's too complicated." The court decided the case would have to start again with a new determiner. Another, far better known case is Campbell and Edwards, where dear old Lord Denning said the reason the decision has to stand is that the 3 parties, the 2 parties and the expert, have made a contract and they must carry it out. Of course, if there is fraud or collusion, the matter is entirely different. Fraud or collusion unravels everything. So, it's rare for a decision to be overturned. None of mine have been. Because I'm an accountant, most of my cases concern company sales, but ED can be used in lots of other ways, and I have done other kinds of disputes. One such was a dilapidations claim at the end of tenancies for a chain of large department stores, where I had to engage a chartered surveyor to look at the dilapidations, which could then be quantified. Another concerned the retirement of a senior partner from a firm of solicitors. The parties couldn't agree on how much that man should be paid out on his retirement, so the matter went to arbitration. A very well-known arbitrator was appointed, and he charged more than the dispute was worth and made a finding just on principles which simply had to be quantified. I was then appointed as expert determiner to quantify his findings. And I had to get into such matters as valuing the law library, valuing the second-hand computers, valuing the boardroom furniture. It went on and on. I could, as an expert determiner, have resolved the whole dispute for less than I had to charge just for the ED part with a clear run, instead of which the parties spent far more than they should have done. But at least they reached finality. The matter was determined. How then am I appointed to make such determinations? Well, there are 2 ways. The parties can simply choose to appoint me. That was the case with the solicitor's retirement I've just mentioned. More normally, I would be picked from the panel of experts, which the president of the Chartered Accountants maintains. I'm one of about 100 on that list, out of 140,000 chartered accountants, so it's quite a short list. And that would come from a dispute resolution clause in the contract for purchase and sale of a company. That's more normal. The case then proceeds, once we've got the contract worked out, with my considering the papers. Typically, each party makes submissions to me. each party is able to respond to those submissions. There is a third stage called the reply, and I as expert can make my own inquiries, and I then make a decision. The beauty of it is as follows. It's usually very much cheaper than going to court, cheaper than arbitration, generally quicker, and it's final. And I hope to say that as with mediation, we reach something which the parties can live with. But whether or not, it's ended. And unlike going to court, there's a better chance that the parties will not be lifetime enemies. I think that's a very satisfying procedure that people should consider more often.